Okay, our stream has started, and it is now 1 o'clock Eastern Standard Time. So let's go ahead and start. Good afternoon. This is the Clerk of the Court, Greg Block, confirming procedures for the oral argument scheduled to be conducted by teleconference this afternoon. If arguing counsel or a judge drops from this teleconference, we will pause the proceedings and clock until the judge and or counsel is reconnected. In accordance with the instructions we previously provided counsel, we will sound a tone that sounds like this when counsel has 3 minutes remaining in allotted time, and a double tone that sounds like this when counsel's total allotted time expires. Arguing counsel in this case are on the call. Mr. Kenny DeHakis, can you hear me?
Yes, sir, I can.
Thank you. And Mr. Nathan Kirshner, can you hear me?
Yes, sir, I can.
Okay, thank you very much. Counsel, stand by while I confirm that the judges are on the call. Our presiding judge is Chief Judge Bartley. Chief Judge Bartley, did you hear both counsel and can you hear me?
Yes.
And Judge Peach, did you hear both counsel and can you hear me?
Yes to both.
Thank you. Judge Greenberg, did you hear both counsel and can you hear me?
Yes. Yes.
Thank you. Judge Allen, did you hear both counsel and can you hear me?
Yes to both.
Thank you. And Judge Meredith, did you hear both counsel and can you hear me?
Yes to both.
Okay, thank you. Judge Toth, did you hear both counsel and can you hear me?
Yes.
Thank you. And Judge Falvey, did you hear both counsel and can you hear me?
Yes. Yes.
Thank you. Judge Lauer?
Yes, thank you.
Did you hear both counsel? Yes, thank you, Judge Lauer. And also, and finally, Judge Jaquith, did you hear both counsel and can you hear me?
Yes.
Thank you. Thank you all. Chief Judge Bartley, the call is configured. Counsel prepared to argue and all participants are ready to proceed.
Very good. Thank you, Mr. Block. You may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable Margaret Bartley presiding. God bless the United States and this honorable court.
Good afternoon. I'm Judge Bartley. I'm joined today via teleconference by all the other judges of the court, namely Judge Peach, Judge Greenberg, Judge Allen, Judge Meredith, Judge Toth, Judge Falvey, Judge Laura, and Judge Jaquith. We're here for the matter of Rocco v. Perciavalle versus Robert L. Wilkie, docket number 17-3766, and we're sitting en banc to reconsider the veteran's appeal of a board decision finding no clear and unmistakable error in a July 1971 rating decision that denied a knee evaluation in excess of 10%. Counsel for the parties, please state your name and your appearance for the record, beginning with appellant's counsel.
Thank you, Your Honor. This is Kenny DeHakis for Mr. Perciavalle.
Thank you,
Nathan
Mr.
Kirshner.
DeHakis.
Oh, pardon me. Nathan Kirshner for the Secretary, and with me at counsel table is Chris Wallace, Deputy Chief Counsel.
Thank you, Mr. Kirshner. As you know, each party will have 30 minutes to present their arguments. Mr. DeHakis, how much time would you like to reserve for rebuttal?
Your Honor, I reserve 10 minutes for rebuttal.
Okay, thank you. We will make that happen. Mr. DeHakis, you may proceed when you're ready.
Thank you, Your Honor. On behalf of Mr. Perciavalle, I want to again thank this court for sitting here today to consider his appeal. This court has convened en banc to address the very important question of when there has not been a change in law in the context of revision of VA decisions based on Q. A change in law does not occur when this court, the Federal Circuit, or the Supreme Court interprets the meaning of a VA statute or regulation for the first time. Such interpretations are why Congress created this court, and they give guidance to the Secretary, the claimants, and the representatives. As the panel correctly articulated, a changed interpretation necessarily requires the existence of an antecedent interpretation from which a later interpretation departs. And because there was no change in law, Section 20.1403E does not apply to this case. When Congress writes a statute, that statute is the law. When the Secretary writes a regulation, that regulation is the law. When either the General Counsel or the courts interpret a statute or regulation, such an interpretation is not a change in law. Rather, this interpretation is an instruction to the Secretary and to claimants concerning what the law or regulation means and has always meant, and also how the law or regulation should be understood and applied. It is an announcement of what the law was intended to do and how it was meant to be applied. This law does not change until an existing interpretation from a precedential General Counsel opinion or a precedential judicial opinion results in a superseding judicial opinion that announces a change in that previously announced interpretation. Put another way, there must be two interpretations, an original precedential interpretation and the changed interpretation. So, for example, where the VA interprets a statute by promulgating a regulation and the court invalidates that regulation by interpreting the statute, there has been a change in law. This is what happened in Jordan and explains why the court ruled that a change interpretation cannot serve as the basis of Q. The Secretary erroneously contends that the board, in this case, was relying on this court's decision in Lamb and the Federal Circuit's decision in Jordan when the board explained that neither this court's decision in Esteban or the General Counsel opinion could be applied retroactively. To the contrary, the board relied upon Lamb to support its application of Section 20.1403E. The board did this without any analysis of either Esteban or the General Counsel opinion and whether those interpretations constituted a change in law. The board relied only upon 20.1403E to support its conclusion, which it misapplied. The board started from the assumption that Esteban and the General Counsel opinion were a change in law. However, as the panel correctly determined, these interpretations did not represent a change in law. Therefore, 20.1403E does not apply to this case. The Secretary
Mr. DeHarkis, this is Judge Bartley.
Yes, ma'am.
The Secretary argues or states in the motion for recon that you're the one with the burden to provide evidence that the rating schedule in 1971 allowed for separate ratings for a single condition. What's your response to that? Do you have that burden?
Thank you, Your Honor. No, I don't believe that we do. And the reason for that is that the Secretary, through its regulations and statutes, is required to apply the law as it is written, unless or until the court or the General Counsel issues a precedential opinion. And those interpretations then tell us what that law has meant from the beginning. In Section 3.103A for the regional office and 7104C for the board, their regulations and statutes direct that they must apply all applicable regulations. So in this case, when 4.71A and its diagnostic codes, through it, the language that are used in those regulations direct a certain result, then that's what the law requires of the regional office when adjudicating decisions. And just because somebody hasn't just because the General Counsel or a court has not explained the meaning of those words, the statutes and regulations still apply.
So, in essence, your position is that on its face, the rating schedule was never limited to a single evaluation for a single condition, and that was how the law existed for many years prior to Esteban?
Your Honor, My response is that that's what the law has always meant from the beginning, and the basis for that statement is the general counsel opinion. Specifically in this particular case, that general counsel opinion said that the plain meaning of those diagnostic codes require separate ratings for arthritis and instability. I can't speak to whether that same whether that would apply equally to a case where there was maybe some ambiguity in the regulation, but at least in this situation, the plain meaning of the regulation required separate ratings. And so based on the general counsel's own opinion, that is what the law required since the inception of that regulation.
Thank you.
Mr. DeHakis, this is Judge Allen. In your description of the law, you noted in terms of what an interpretation was, that the interpretation that needs to have been changed by something that comes later must be one that is precedential in nature. What is the authority for that as opposed to, for example, the position that prior to either Esteban or the general counsel's opinion, VA had to interpret in a sort of colloquial sense the rating schedule with respect to this issue because it's clear that there were cases in which this issue was addressed. So on what do you base your position that the prior interpretation only counts as an interpretation if it is precedential?
Thank you, Your Honor. Yes, the authority, as I said, was in statute and regulation 3.103A mandates that they must apply the regulations. And judicial precedent, in particular Rivers at the Supreme Court, Rivers v. Roadway, and tells us that the meaning of a statute when it's given to us by a court, or in this case a general counsel opinion, tells us what it has always meant. And a non-precedential interpretation has is not binding on anyone. And I would equate that to, say, an M21 provision, which has not been raised in this case, but an M21 provision is simply instructions to the raters at the agency level. And the Federal Circuit ruled in DAV that those are not binding on anyone. And when the board is making a decision in particular, the board must apply the law as it is written. And so even though the agency may informally interpret it, if there is no set precedential binding interpretation, then it cannot, and the decision does not conform with the plain meaning of the regulation, then it cannot serve as a formal interpretation. The Secretary next points to George v. Wilkie, but likewise misunderstands its ruling. The Secretary asserts that George holds that a new or novel interpretation of law cannot ever form the basis of Q. However, George represents a parallel to Jordan. Once again, a claimant was trying to use a ruling in Wagner on the basis of Q in a pre-Wagner regional office decision. This court emphasized that the RO in 1977 was required to apply the regulation that represented the Secretary's interpretation of the statute, even though that regulation was in conflict with the statute. Now, this decision is on appeal to the Federal Circuit and is not final. However, any decision on that appeal will not affect this case because the law announced in George is the exact same law announced in Jordan. And the Secretary has cherry-picked a phrase but forgets that George is simply applying Jordan's rule that the regulation represents the VA's interpretation of a statute. Therefore, the regional office cannot clearly and unmistakably err by applying that law, even though it may be incorrect. A later decision by the court or the general counsel that changes that interpretation does not apply retroactively to any final decision. The original interpretation of the statute in Wagner did not represent the change in law. The change in law occurred when the Secretary, through his general counsel, invalidated the VA's regulation based on the ruling in Wagner. All the ruling in Wagner did was offer the original interpretation of the statute. It was not until the Secretary invalidated his own regulation in the general counsel opinion that a change in law occurred. So again, we see, as articulated by the panel in this case, that a change interpretation necessarily requires the existence of an antecedent interpretation from which a later interpretation departs.
This is Judge Meredith.
Yes, ma'am.
I'll jump in. You mentioned that the board in the decision on appeal cited Lamb for the proposition that a recent or novel interpretation cannot be used to support a Q motion. You've asked in your response to the Secretary's motion for full court review that we consider overturning Lamb. Under principles of stare decisis, we should only overturn prior precedent if there's a special justification, and usually an opinion being wrong is not enough. Can you tell us on what basis you are suggesting that we could or should overturn Lamb?
Yes, Your Honor. And when I argued that the portion of Lamb should be overturned, I was referring to the fact that the Secretary is asserting that Lamb rules that a new interpretation on its own cannot be Q. And I would equate that to what I've described here today as the original interpretation. And if the court agrees that the very first or original interpretation represents a change in law, or that it cannot be the basis of Q, then I would ask that that part of Lamb be overturned as inconsistent with the regulations for Q in both Part 3 and Part 20.
So essentially, you disagree with Lamb is the basis.
Yes, Your Honor. I disagree with how the Secretary is presenting Lamb as saying that the very first or original interpretation either is a change in law or cannot serve as the basis for a clear and unmistakable error.
Okay. On a different topic, I want to talk to you about prejudice and manifest outcome change. So far, you've argued, as you did in your briefs, about the law and whether the board committed a legal error in its conclusion. In your briefs, in your analysis, you didn't talk about the evidence that was in existence at the time of the 1971 rating decision. How can you show a manifest outcome change and therefore prejudice without showing what the evidence was in 1971 and whether it would have undebatably entitled the appellant to two separate ratings at that time?
Yes, Your Honor. And the reason I would argue that the evidence in the record is somewhat unimportant to this question. The panel in this decision, relying on Simmons, determined that the prejudice exists because Mr. Perciavalle never got his day in court, so to speak. The board never reached the merits of the Q motion and instead said that it was precluded as a matter of law. When we contrast this, what happened in Simmons, in Simmons, the board actually adjudicated its Q motion and also determined that it was that there was no manifestly different outcome. Now, even though it may have been an incorrect interpretation or there was some error there, the court determined that he was not deprived of a meaningful opportunity to participate in the adjudicative process because the board actually addressed his appeal. In this case, the board never touched the merits, and that in itself, under Simmons and the line of cases that it relies on going back up to Sanders, is sufficient proof under the facts of this case to show prejudicial error.
So in Simmons, though, didn't the court actually go through the analysis and look at the evidence in existence at the time of the RO decision and concluded that there could not have been a finding of Q based on that evidence. So if we were to undertake a similar analysis in this case, was there any evidence in 1971 that the appellant had a clear diagnosis of arthritis, and was he service-connected for arthritis at that time?
To your first point, Your Honor, it's true that the Simmons court did go through the evidence, but that was only after determining that he had already been given an opportunity to participate in the adjudicative process. And for that reason, they moved to whether the evidence supported Q in a prejudicial analysis. And again, I want to point out that in this case, Mr. Perciavalle never got that from the board. And under the Supreme Court's ruling in Chenery, I don't believe that the court can address the merits of the Q determination unless or until the board does. That being said, if the court does reach that, I would present that the X-rays in the case did show arthritis in the knee, and that the presence of arthritis required a separate rating in addition to his already service-connected instability.
And that's based on something in the record that contains a diagnosis of arthritis, or your reading of the X-ray evidence?
The X-ray, Your Honor, I would say that the X-ray does show arthritis.
Sorry, and one final point I don't believe you answered. Was the appellant service-connected for arthritis at that time in 1971? And if not, could he have gotten a separate rating for that condition?
He was not service-connected for arthritis per se, but he was service-connected for disability within the knee, and I would say that the cause of that disability would be the basis for service connection. And if arthritis is causing it, then that would be the diagnostic code that would be used. Under my reading of the statutes and regulation, it's the disability that is service-connected and not necessarily the diagnosis, although in this case the X-ray depicting arthritis is sufficient proof to service connect because of the various presumptions as well as just the general policy on service-connected conditions.
But again, is that all based on your read of the evidence, not what was actually said in the evidence at the time? I mean, did they diagnose arthritis and say that was the cause of any limitation of motion or
the CMP exam? I actually don't know the answer to that, Your Honor. It is in my brief, and unfortunately I don't have that right before me, but I can address that in my rebuttal to make sure that I answer your question.
Okay, thank you.
Mr. DeHakis, this is Judge Bartley. I see that in your, well, it wasn't it looks like it was a lay representative at the time, but the March 2015 Q motion does discuss the evidence and the why there should have been a changed, why there would have been a changed outcome. And I note some discussion about the X-ray question that Judge Meredith was just referring to, but are you also, I recall, perhaps it was in a later submission, are you also arguing that there could have been a 10%, should have been a 10%, an additional 10% from the one he had, based on 4.59 or no? Was that somewhere in your pleadings?
Yes, Your Honor. Well, 4.59 applies generally to the joints and represents the regulatory mandate that that the functional loss be given the minimum compensable rating. And I think when you combine 4.59 with 5003, when you have arthritis and functional impairment, that it requires the minimum compensable rating.
So as far as the merits of the Q argument go, you are combining the 4.59 with the arthritis argument, or is it a separate standalone for a 10%?
It would be just the additional 10% rating for the presence of arthritis in a major case.
Okay. Okay, thank you for clarifying that. Let's see, the time has expired, but I will check with the judges to see whether they have any additional questions. Judge Peach, do you have any further questions?
Did you say Judge Toth or Judge Peach?
No, Judge Peach.
Okay, thank you. I do have a question for counsel. From the 1971 to, which is the date that Mr. Perciavalle had submitted his claim, to 1994, which is the date that Esteban was delivered. Did the court, did the board, the RO or the board interpret the law that they could not get 2 ratings, that this was pyramiding? Is that how it, excuse me, is that how it's been interpreted for those 22 years?
Your Honor, I don't believe so. It's a little unclear in the case law. I was unable to find any formal interpretation by the VA on pyramiding, and the first time the courts addressed it was in Brady v. Brown, and from what I can tell, this seems to be the first time that this court interpreted 4.14 as precluding rating the same symptomatology more than once. And it looks like that ruling was used in Esteban in the specific facts of that case, where they were looking at scars, and I believe it was a nerve or a muscle injury. And so it was unclear when the courts first articulated, although I think it's in Brady, but I was not able to identify any formal interpretation by the court or the VA as to how 4.14 should be used when there's separate symptomatology.
And so it's your belief that it would, as to the interpretation of the law, it would have to be something that either the General Counsel's office came down with something, or that the VA placed a regulation, passed a regulation, or that the court came down with an interpretation, that it does not include an application by the RO or the board of what their interpretation is of that particular provision.
That's correct, Your Honor, and relying on DAV again, regardless of what the board or the raters assert or how they individually interpret the regulation, the courts or the OGC in this case are the ones that give a binding interpretation, and until it's binding, there's no set definitive definition from which to deviate in a change.
Thank you. And with just a follow-up on Judge Meredith's question with the manifest outcome, based on the situation in 1971 and including up to 1994, do you think it was a plausible interpretation that was made by the RO at the time and the board?
No, Your Honor, I do not, because again, relying on the General Counsel's own opinion, they describe the regulation as being as clearly the clear language of the regulation or the plain language of the regulation. I don't remember the specific term, but they essentially say that there's no ambiguity in these specific diagnostic codes as to whether they represent a different symptomatology or a different disability.
Thank you. I have no further questions.
Thank you, Judge Peach. Judge Greenberg, do you have any further questions?
No questions.
And Judge Allen, do you have further questions?
I have one, if I could, Chief. Mr. DeHakis, if you can just assume with me this hypothetical that there is a regulation about something on the books, and a court, our court, interprets the regulation in a certain way based on its plain language. Now, you agree with me that just on what I've told you now, that you couldn't argue this court decision is retroactively applicable for purposes of Q. You agree with that?
No, Your Honor, not entirely. If the regulation is interpreting a statute, as in Jordan, then I would agree with you. But I would argue that if it's a standalone regulation, that is the meaning of that regulation from its inception, and the VA had an obligation from its inception to correctly apply it as it is written.
And the support for that?
First, I would point to the Supreme Court's decision in Rivers v. Roadway, where although they were interpreting a statute, they did say that it's an announcement of what the law was intended to do and how it was meant to be applied. Furthermore, in the non-precedential opinion of Patrick, and I forget which one exactly, the Federal Circuit sent back a Q motion where the appellant was arguing that the plain language of the statute, at that time I think it was 311, it's now 1111, was incorrectly applied based on the plain language of that statute. And I understand that there's a kind of a break when this court ruled in George that the VA had an obligation to apply the regulation, but in your hypothetical there would be no regulation, and so in that case the Federal Circuit, although non-precedential, I think is very helpful because it remanded, or rather it vacated the Veterans Court, this court's decision, and it appears that when it went back to the board actually granted the Q motion based on the incorrect application of that statute. And so I would say that the non-precedential Patrick, which also relied in part on Rivers v. Roadway.
So if I can just follow up and then I'll run. So you're drawing a distinction then between regulations that purport to resolve an ambiguity in a statute versus regulations that fill a statutory gap. Is that what you're doing? Something that, do you follow me?
I do, Your Honor. I'm not sure that there is a distinction. The regulation is the VA's best guess at what the statute means, and if it's found invalid because it's inconsistent with the statute, I'm not sure if it matters whether the statute is ambiguous or not.
Well, the reason I asked the question is you seem to be saying that what distinguished my hypothetical so that you couldn't agree with me fully was whether or not the regulation that was at issue was, you said, interpreting a statute, or you called it a standalone regulation. But of course, regulations can't really just float in the ether, right? They either interpret an ambiguity in a statute or they fill a statutory gap. And so I'm trying to understand how the answer is different. because it's difficult for me to get around Jordan, because if in fact one can simply say a court looks at a regulation, says the plain language means X, and if the Federal Circuit in Jordan said that can't have retroactive effect for Q, then it's difficult for me to see how one can say, well, don't pay attention to that later case, just look at the plain language. And you sort of get into the back door what the Federal Circuit said you can't come through the front. So that's why it's important to me, this standalone regulation versus interpreting a statute point.
Yes, Your Honor, and I'm sorry, I misunderstood, or I missed the part of your question. When there's a gap-filling regulation, like the one we have here, then I do believe that the very first time the court presents its interpretation and it's the plain language of that regulation, then that can serve as the basis of a Q. And at least under current case law with George, if the regulation is interpreting a statute even though the statute was plainly misinterpreted or misinterpreted based on the plain language, then the panel in George ruled that the regulation is still a law that the VA must follow. And so that's the distinction, I think, and I hope that gets to the point of your question.
Thanks, I understand, and I don't have any further questions, Chief.
Judge Meredith, do you have further questions?
I do not. Thank you.
Judge Toth, do you have further questions?
Yeah, I have one question, and I've a bit of deja vu because I think this is a variant of the question that I asked you about whatever it was, a year ago at the last oral arguments. And it's sort of a variant of the question Judge Allen just asked. But so, I mean, the lack of an established interpretation might get you around the threshold piece of whether this 20.1403 applies. But how does it then speak if we kind of get to the prejudicial error piece and we sort of assume there's no facts in dispute or anything? Doesn't the lack of an established interpretation also sort of leave you without a foothold to kind of demonstrate error? Right? Do you understand my question?
I think I do, Your Honor, and my response would be, again, to say that the VA has an obligation to apply the statutes and regulations as they are written. And at least in a case where the language is plain, as we have here, they have no wiggle room. And perhaps it would be a different result if there was some ambiguity within the regulation. Unfortunately, we don't have that situation here, but I think particularly when the language is very clear and the VA themselves say it's very clear, then the regional office has no alternative but to apply it exactly the way it's written.
But let me ask you this then. I mean, is there a difference between, say, the standard of review on just a straight legal question, right, which in a direct appeal would be de novo, versus, a Q claim by statute, that's a clear and unmistakable error, right? So, I mean, something on direct review, if it's a de novo interpretation, I mean, it could be a fairly decent interpretation by the board. It's just not the best, right? It's not the most adequate interpretation. So we could sort of rule against it on those grounds. Whereas, I mean, Q, it has to be unmistakably wrong, right? I mean, do you see a difference in those two standards in terms of how to approach this?
I do, Your Honor, and I think one, I would just point out again that in this case the board never reached those questions, and so we are unable to really talk about what they did or didn't do. We can look at the evidence and kind of divine, so to speak, what we think the regional office knew or didn't know, but until the board says so, there's nothing to review. But in a situation, a hypothetical where the board did address the Q and made certain fact findings, then the clear and unmistakable error would exist in this situation if the evidence showed arthritis and that they should have service-connected it as a separate disability under the plain meaning of the regulations.
Okay, thanks.
Judge Falvey, do you have further questions?
I do not. Thank you.
Judge Laura, do you have further questions?
No, thank you, Chief.
Judge Jaquith, any questions?
Yes, Chief, please. Mr. Dohakis, what beyond the relation back of the general counsel opinion in 1997 supports your assertion that the law in 1971 mandated a separate rating?
Thank you, Your Honor. I would point first to 38 CFR 3.103A, which again requires the VA to, and I'll quote here, the proceedings before the VA are ex parte in nature, and it is the obligation of VA to assist a claimant in developing the facts and to render a decision which grants every benefit that can be supported in law while protecting the interests of the government. And this regulation requires that the VA apply every law exactly as it's written based on the plain meaning of that regulation and to award benefits when supported by the law.
And it's your position that that meaning was sufficiently plain?
Yes, Your Honor, and I'm relying specifically on the general counsel's opinion, which said that the meaning was plain.
And to follow up on the answers that you gave to Judge Peach, it doesn't matter, is it your position that it doesn't matter what the application of the regs was leading up to that 1997 opinion?
That's correct, Your Honor, because whatever the individual raters or even internal instructions are not binding on the VA. Well, in most instances, they're not binding on the VA. The raters are required to follow either the regulations or the binding general counsel opinions, and anything else is not a binding requirement.
And in any event, is there any information in the record beyond the one case you mentioned that was cited in Esteban that tells us what that application or what the practice was?
No, Your Honor, I did not uncover any evidence that showed what the general practice was at that time.
Thank you. I don't have any further questions.
Okay, thank you, Mr. Dohakis. Mr. Kirshner, you may proceed.
Your Honor, and please the court, Nathan Kirshner for the Secretary. Your Honors, the board's July 2017 decision here was not arbitrary or capricious, and it should therefore be affirmed. As I think the court acknowledged, the Q is an extra heavy burden that appellant here has not carried. Any error on the part of the board here was harmless because the RO's reading of the interplay between section 4.14 and the relevant diagnostic codes in 1971 was plausible. There are three possible avenues for this case to travel that all end in favor of the Secretary. First and most likely is, as the board found, Q is prohibited by 20.1403E and 3.105 because Esteban and the General Counsel Opinion 2397 represented a new interpretation of the extant regulations. Second, less likely, Esteban and the General Counsel Opinion were the first or novel interpretations of that regulation, and a new interpretation cannot be retroactive. And third, assuming that the regulations and diagnostic codes were static and have not changed since 1971, the facts are not so clear that the outcome would have been manifestly changed. Your Honors, this case turns on understanding and plausibility. A change in an interpretation of a statute or regulation cannot constitute Q under 20.1403E and 3.105A. The court in the panel decision defined what a change means, but it did not define interpretation. Looking at that word, if I get my Black's Law Dictionary off my desk, my little pocket version, it gives two different definitions that are potentially applicable here. First is the process of determining what something means. And second, perhaps more useful in this context, is the understanding one has about the meaning of something. The understanding of the interplay between Section 4.14 relating to pyramiding and the knee diagnostic codes has changed over time. The language of the relevant regulations and diagnostic codes has not changed, but the interpretation has. There are memorandum decisions prior to Esteban that show a more broad interpretation of the pyramiding concept, and I'm happy to give those docket numbers and citation if the court's interested. I found two of them. Then there's Brady, and then there's Esteban, which explained pyramiding. After Esteban, there's a memorandum decision called McAderoy, which questioned how Esteban would apply to knee cases. After that, we have the General Counsel Opinion 2397 that notes that the reason for the General Counsel Opinion was because of three cases that were remanded from the court that posed the question. Since then, since 1997, we have the Federal Circuit's case in Delisle, which found that Diagnostic Code 5257's plain language applies to instability of the knee. Then there was another memorandum decision called Burrell, which discussed how Delisle would be interpreted in light of, I believe it was an M21 provision. Then we have the board decision currently on appeal. And then finally, and most recently, we have this court's decision in Lyles, which found that separate ratings were permissible under Diagnostic Codes 5259 and 5261. So since the time of the 1971 decision, the interpretation, when interpretation is considered to mean understanding of the interplay between these two regulations, has certainly changed. And that is what the board found here, and that is what the board found could not be Q. Importantly, the board, in making that finding, addressed appellant's contentions directly, contrary to appellant's argument. The board noted, and this is at page 6 of the record, that appellant argued that Esteban and the General Counsel Opinion clarified existing regulations as opposed to changing them, so their interpretation should have retroactive effect. And this goes along with what was stated both in the Q motion and in appellant's explanation of the Q motion that came later in the record. I believe it's at pages 13 and 14. Appellant in the explanation himself used the word that Esteban and the VA General Counsel Opinion clarified the meaning. And that's important too, because if we go back to the two definitions of interpretation that I just read to the court, the first one, the process of determining what something means, is actually supported by a Federal Circuit decision called Forshee. And in Forshee, the Federal Circuit considered, and it's a 2002 decision, they considered the definition of interpretation. And they note this definition from Black's. They also noted that from the shorter Oxford English Dictionary, they defined interpret as to expound the meaning of, to render clear or explicit, to elucidate or explain. And that's basically the same thing as clarifying. So in essence, appellant is stating that what Esteban did and what the GC opinion did was to clarify the regulation. Given that,
Kirshner.
Yes, Your Honor?
This is Judge Bartley. So you said a moment ago that in the veteran's Q motion, he had referenced Esteban. Can you give me the record site for that?
Oh, sure. 1 second, Your Honor. Happy to. I'm not sure if it was in the Q motion itself, but it was definitely in the
well, I'm sure it wasn't. It was not in the. It was not in the Q motion.
Yeah, it was in the clarification.
His argument in the Q motion was that a separate rating was not considered, erroneously not considered.
That's correct, Your Honor.
And that's what he has on page 102.
That's correct. Esteban, his reference to Esteban comes in at page 14 in the clarification.
And that is after a rating decision that talks about the general counsel decision. Is it not? So the VA raised the issue of the later change, and then the veteran discussed it.
That's correct, Your Honor. The VA said that the basis for the Q motion would have been under Esteban, and Esteban constituted a change in interpretation.
So it seems from the record. It seems from the record that it's the VA that raised the Esteban general counsel in his Q motion.
I'm sorry, Your Honor, I couldn't hear you. Broke up a little bit.
It seems that it's the VA who raised Esteban and the general counsel opinion, and not the veteran in his Q motion.
That's correct, Your Honor. I don't think I was asserting that appellant raised Esteban, but he noted that Esteban clarified the regulations. And so clarified means to have an effect on the understanding, clarified the understanding. So Esteban could constitute a interpretation of the regulation, even given appellant's response to VA's bringing up Esteban. This is all to show, Your Honors, that essentially the understanding of the interplay between these regulations has changed quite a bit over time. And therefore, the interpretation has changed over time, at least given this one definition. Because a change in interpretation cannot constitute Q under the regulations themselves, 20.1403E, etc., the board's finding was correct.
Now, Mr. Kirshner, this is Judge Bartley. Whenever we're looking at Q, aren't we supposed to look at the laws, the state of the law as it existed at the time of the decision that you're claiming Q against, which is 1971. So what was the state of law as to the interpretation of 4.14 or the issue of whether a veteran could get a disability evaluated under two separate diagnostic codes? What was the state of the law as to those two issues in 1971? And what evidence do you have as to that?
Of course, Your Honor. Unfortunately, it's not terribly clear. There's a distinction here between a change in law and a change in interpretation of the law. And the law, as it is written in terms of statutes and regulations, assuming that that is our definition of law, there's been no real change in the law from 1971 until now. 4.14 is the same. The diagnostic codes are pretty much the same. The one potential change in the law, if we're again considering it to be...
Mr. Kirshner, can I interrupt you here? And I apologize for doing so, but I specifically did not ask you about a change in the law. I asked you what was the state of the law as to the interpretation of 4.14 or the notion of evaluating a veteran's disability under two separate diagnostic codes in 1971.
Of course, Your Honor. In 1971, the state of the law was that there was no formal guidance. There was only the language of the regulations, and the rating boards at the time, because it was a rating board made up of, I believe, 2 raters and a physician, were tasked with applying those regulations. 4.14 started then, as it does now, noting that the the evaluation of the same disability under various diagnoses is to be avoided. So from going back and looking, I mentioned the memorandum decisions before that I could potentially bring up. I've looked at those. I've also found some old board
decisions. Mr. Kirshner, those, because the court didn't open its doors until 1989, those would necessarily have come after 1971, correct?
That's correct, Your Honor. I think the status of the law, the state of the law in 1971, if we are taking a snapshot, is that the interpretation of this regulation was up to the rater. It wasn't a formal interpretation, but it was an understanding based on reading the regulation of what was to be done. And from this case, it certainly appears that the rater believed that it was pardon me, Your Honor.
So, go ahead.
It appears the rater here was concerned with pyramiding, especially given the facts of this case. In this case, at the time of the 1971 decision, there is not a diagnosis of arthritis. There is a notation in an X-ray report of questionable joint space narrowing. It uses the word questionable. Appellant was not service-connected for arthritis at that time. He was only service-connected for the residuals of a meniscectomy, and he was rated under the diagnostic code that specifically links to removal of semilunar cartilage that is symptomatic. And also, it's worth noting.
So, Mr. Kirshner, your response to my question about what the rules were as far as giving a veteran's disability, evaluating a disability under two separate diagnostic codes, is that the proof that we have is the actual rating decision itself, which doesn't mention pyramiding or separate diagnostic codes.
No, Your Honor, it doesn't. But it does mention the disability for which appellant was service-connected, which was the removal of semilunar cartilage. That's the specific diagnostic code used, and his diagnosis in the record is symptomatic removal of semilunar cartilage. It's a pretty close match, Your Honor. So, unfortunately, Your Honor, this is a case where there just is not much in the record. And there is not much in terms of a formal interpretation of these regulations at the time. Nevertheless,
was there an informal interpretation?
I don't know that there's one in the record, Your Honor. I don't think that there is one in the record, but the only thing that's necessary is for whatever interpretation there was at the time to be a plausible one. And I think here, reading the pyramiding regulations along with the diagnostic codes of the time, for the RO to make the decision that it did in 1971 is plausible, and the board's decision, doesn't stray from it. There's no error there in the board's making that finding. So again, Your Honors, whether it is a change in the interpretation of these diagnostic codes and their interplay with 4.14, or whether the Esteban and General Counsel Opinion 2397 represent a new or novel interpretation, either way, neither of those things can constitute Q. And as I touched on before, the facts of this case...
Could I jump in there? In
yes, Your Honor.
In your motion for reconsideration or full court review, you relied on Lamb for the proposition you just stated that a new or novel interpretation can also not be the basis for Q. Could we get you to respond to the appellant's argument that perhaps we should consider overturning Lamb and whether we could or should do so under principles of stare decisis?
Thank you, Your Honor. Yes. No, we don't believe that the court should overturn Lamb. We think it would be helpful for the court to clarify where it is on Lamb, but we think Lamb should be upheld and affirmed, even if we look to the Fed Circuit's case in DAV. DAV discussed the retroactivity of a new interpretation of a regulation, I do believe, and they found that it would be inappropriate to apply a retroactive interpretation in the Q context. I believe they relied on the Supreme Court case, Virginia Department of Transportation, for that proposition. So it's all right to apply a retroactive interpretation to cases that are open for review at the time, but it would be inappropriate to apply them retroactively in the context of Q, because Q is about a collateral attack on an already final decision. Essentially, if the court were to go with appellant's argument and overturn Lamb, it could turn this court and the General Counsel's office, when it issues opinions, into a Q factory. Every change, every precedential decision, by the court or by General Counsel, could open up the doors to a new raft of Q challenges. And I don't think that is at all what the regulations are meant to do.
Counsel, this is Judge Toth. I just want to hop in. I mean, the exceptions to finality that Q presents, I mean, they're from Congress. I mean, they're from 38 U.S.C. 7111, right? I mean, obviously, Congress has not drafted any civil statutes, with exceptions to finality. So, I mean, that has some significance, does it not?
It does, but in doing some of my research for this, I've noticed also the interplay between Congress and these statutes. I don't think I think 3.105A may have predated 7111, Your Honor, and then after 7111, VA promulgated 20.1403E or 20.1403 that would have applied 7111 specifically to board decisions. In promulgating that regulation, in the federal register.
Right, but 20.1403 has the terms otherwise correct. I mean, that seems to, that would seem to suggest it doesn't apply to purely, to admittedly legal errors, right?
Well, I believe it's an otherwise correct interpretation, Your Honor, yes.
Right. I guess what I'm saying is that obviously, finality is a serious business in the law, and exceptions to it are rare. But this appears to be one case where Congress expressly made an exception to finality. I'm looking at your argument, and it strikes me that by application, there would be virtually no way that any legal error, purely legal error, could constitute Q under your argument.
Well, again, Your Honor, it's supposed to be rare. It's supposed to be very rare. I don't know what hypothetical instance.
Well, there's a difference between rare and non-existent, right? I mean, I'm getting non-existent from you. I understand clear and unmistakable. We might maybe focus on that unmistakable part as being maybe a directive from Congress that this is an extremely rare error and something, maybe a different type of error than de novo review would obtain. But like to just read out legal errors altogether, it seems to me, I mean, I'm looking at the statute and I'm just not seeing it.
Yeah, Your Honor, I'm going to have to go back to the general standard with regard to Q challenges. It would preclude certain, purely legal challenges from being Q, but the test there is the plausibility test that goes back to Berger. So if the court takes the look at the original decision and finds it's a plausible reading of the law, even if the court doesn't agree with it, then it's not Q. It has to be something that is, even beyond plausible to meet that Q bar. But I think that with what happened with 7111, and I can clarify later perhaps if Your Honor would like, I believe Congress came in and did 7111 after 3.105A had already been on the books. So that, again, kind of gets to the unsettled nature of Q, but not as much with Q as the other, the diagnostic code and the other regulation involved about pyramiding.
Thanks for that. You don't have to submit anything further on that. Thanks.
Thank you, Your Honor.
Mr. Kirshner, this is Judge Bartley. Assume that we were to find here that there was no change in law under 20.1403E. Could we or should we address the merits of the Q motion, even though the board did not address the merits?
Your Honor, I don't believe that the court can address directly the merits of the Q motion, but nevertheless, I think in any decision, even relating to Q, the court's bound by the rule of prejudicial error. So the court would have to do a harmless error analysis in order to determine whether any error on the part of the board here was harmless. So here, the Secretary believes that any error on the part of the board was in fact harmless, given the evidence of record at the time, which again showed not only no diagnosis of arthritis, just a questionable notation from an X-ray report, and also no complaint of pain. The appellant noted in a report on an examination that he had, I believe it was discomfort going up and down stairs, but there was that discomfort wasn't found on the examination, and the examination report itself said no functional defect. So given all of that, if the court were to undertake a harmless error analysis, which I do believe it would have to do, it should still find any error on the part of the board harmless.
Thank you.
Mr. Kirshner, this is Judge Jaquith. Doesn't Berger address this situation where the adjudicator's interpretation of the law was Q? Isn't this a Q by definition, the incorrect application of the regulatory provisions that were in existence in 1971?
We don't believe it is, Your Honor. Berger did address that type of a situation, but the question when it comes up as a Q claim is not whether the court would have done it exactly the same in 1971. The question is whether there was a plausible basis for what was done in 1971. So in order for the court to find that there was Q in this situation, they would have to find that appellant has carried the heavy burden of demonstrating that what the board did in 1971 was not even plausible. And the plausibility language itself comes from Berger, where they state if there was a plausible interpretation in the context of the body of law that existed in 1969, then there's no basis for such a claim, meaning a Q claim. They also talk about, in that case, how in 1969 there were multiple potential interpretations that depended upon the facts of this case. And I think what we have here is a situation in 1971 where the law was not particularly clear. It is still being clarified to this day, in fact. And based on that, the rater in 1971 did the best they could do. And as long as the best they could do remains plausible, there's not a Q challenge that can appropriately lie.
But is there any information in the record on any of that?
In terms of what, Your Honor?
In terms of what the situation was in 1971 or anything out in terms of the law and developments, those are all much later. And all you have pointed us to is the documents that the adjudicator used or completed.
Yes, Your Honor. It was, unfortunately, it was a very different system back then. Raters were not required to give the lengthy explanations that they are now for their decisions. You know, there was no official guidance regarding the 4.14 or these diagnostic codes. But if you look at the language at 4.14, it's certainly plausible that a rater could look at that and say, there is one diagnosis here on the record. I am going to rate that diagnosis. I am not going to go any further because I shouldn't be pyramiding.
Even in the face of separate diagnostic codes and the later VA General Counsel's Office opinion that says the plain terms of the diagnostic codes permit separate ratings.
Well, Your Honor, you asked about 1971 and what things looked at that moment. And at that moment, there was no guidance. At that moment, there was no General Counsel opinion or Esteban. And the General Counsel opinion only came about after Esteban, once the General Counsel started being asked, you know, this issue started coming up at the court. So prior to that, again, I could provide a few memdecs and memorandum decisions, and I can also provide some board decisions that show that it was not uncommon for multiple aspects of a disability that today we would consider should absolutely be separately rated to not have been separately rated. The board would look at the entire disability picture and decide that the rating was sufficient, regardless of whether, I believe one of the memorandum decisions I have talks about a knee injury that also involves muscle injuries. And of course, nowadays we would piece all of that out. But the board, and in this memorandum decision the court discussed, the board just said, you know what, that is all part of the same disability and that would be pyramiding. So we are going to only rate, you know, the single disability. And especially if you start going back to, you know, board decisions earlier than that, I think I have some as far back as 1988. You know, it's very clear that it was a much more general consideration. Things were applied much more generally. And I guess you could say that the pyramiding regulation was applied much more liberally. And as the evolution of the interplay between these two parts of regulation, between pyramiding and the knee diagnostic codes have gone on, pyramiding has become less and less liberally applied, and more specific ratings, specific separate ratings have become possible. And all that, Your Honor, in my mind, certainly is evidence of a change in interpretation over time. But if we slice it off in 1971, we only have the language of the regulations. There's no other guidance that we can look to. We can just look at the regulations and the evidence of record.
And so on that 1971 record, we have unambiguous regulations implementing an unambiguous statute, and that's much different than Jordan and the other cases. Isn't that right?
Only if you consider the regulation unambiguous, Your Honor. I think there is some ambiguity in the regulations, but that ambiguity was brought out by Esteban. I think it was much more of a blunt instrument at that time, starting with, the pyramiding is to be avoided. That's the first sentence, and that is the sentence that up until the time period of around Esteban, you see cited most often. So once the raider in 1971, yes, Your Honor.
Oh, Mr. Kirshner, that's to the exclusion of the last sentence, which makes clear that it's the same manifestation evaluation under different diagnoses. That's to be avoided. My point being, they would cite the first sentence to the exclusion of the rest of the reg, including the last sentence.
Well, Your Honor, they didn't cite too much of it at all, but they like in here, of course, there is no citation in the rating decision. When they did cite to it, it was mostly for the first sentence, and the first sentence, as I believe was referred to when the court first cited to it, I believe it was in Brady, which predated Esteban, noting that, the pyramiding should be avoided. And then after that, they would get into potentially more detail. But again, none of this happened in this case, but all that the Secretary has to show here is that what happened in 1971 was based on a plausible reading of the regulations and diagnostic codes at the time. It doesn't have to be the correct interpretation as we would perceive it now. It just has to be plausible. And moreover, appellant has to demonstrate that it is not plausible, and they haven't carried their burden to do so here.
I don't have any more questions.
Well,
thanks.
Okay, thank you. Let's just run through since the time rang already. Judge Peach, do you have any questions for Secretary's counsel? Judge Peach?
Okay, I do have a question. Counselor, you have stated that your definition or a definition of interpretation in the context of 20.1403E, that the definition of interpretation, a change in the interpretation, is that interpretation means that it's a way of explaining or clarifying things or a process of determining what something means. Now, how do you do that? Do you do it through some sort of announcements VA-wide, or do you do it through some sort of opinions that are circulated, or how do they know what the interpretation is of a particular statute to determine that it's been changed or not, that the interpretation has been changed?
Well, that's a good question, Your Honor. I think that really it doesn't necessarily have to be an agency-wide interpretation to be talking about what we're talking about in terms of what happened in 1971. Of course, precedent opinions, case law, regulations can all interpret statutes. A precedent opinion can interpret a regulation. But I believe at times the court has even discussed M21 provisions as a way that the Secretary would be shown to be interpreting something, even though those are not necessarily even binding on the board. So in terms of how a thing is interpreted, there's not always something that's written down. I think that when you look at it in the Q context, you just need to look at what happened at the time of the decision and whether it's plausible based upon the regulations. I don't know that you necessarily need to have an official interpretation, or as appellant put it in their response to our motion for reconsideration, a proclamation as to what the official interpretation is. The question is just whether whatever interpretation may have been at the time, even if it was in the mind of the rater, whether it's plausible.
I have no further questions.
Judge Greenberg, do you have questions?
No questions.
Judge Allen?
I don't have any questions, Chief. Thanks.
Judge Meredith, do you have any further questions?
I do not. Thank you.
Judge Toth, do you have further questions?
I do not.
Judge Falvey?
I do not. Thank you.
Judge Laura?
No, thank you, Chief.
Judge Jaquith, any further?
No, Chief, thank you.
Okay, thank you, Mr. Kirshner. Mr. DeHakis, you may proceed with rebuttal.
Thank you, Your Honor. First, I want to start by pointing to the question about the evidence. I did find it at the RBA 495. There is a VA examination from 1971 which records reduced limitation of flexion down to 135 degrees and normal being 140. And so that would be sufficient evidence, which we did point out in our brief, and was pointed out by the appellant in his original Q motion to represent disability, as it is functional impairment, which is defined by the VA in their own regulations as being the inability to perform the moving functions of the body with the requisite strength and so on. As far as the rebuttal is concerned, I would just like to start that by bringing the court's attention back to the actual issue that we are concerned with here, and that is whether Esteban or the general counsel opinion represents a change in law. And as the Secretary just admitted, there is no evidence of any interpretation by the VA that they ever interpreted any of these regulations. In fact, he said that he used the term, there is no guidance given to anyone. He later asserts that in the mind of the rater is permissible as being an interpretation, even though each individual rater may have a different mind depending on what's going on that day and whether they received the proper training or not. And so I think it's dangerous for us to allow an interpretation to rest on the quality of the training, the experience of the raters, or just whatever they wanted to do that day, whether it represents what the law says or not. The plausibility of an interpretation is, rather an interpretation of a regulation can never be plausible if it conflicts with the plain meaning of the regulation. And I want to read here from the General Counsel's opinion, and this is in paragraph 3, since the plain terms of Diagnostic Code 5257 and 5003 suggest that those codes either apply to different disabilities or to different manifestations of the same disability, the evaluation of knee dysfunction under both codes would not amount to pyramiding. And again, I want to emphasize that they use the term plain terms of these regulations. And so any definition, any interpretation, whether it's in the mind of the individual rater or in a board's decision, cannot be plausible if it conflicts with the plain meaning. I also want to assert or respond to some discussion that the Secretary began with Esteban. He asserted that we had argued somewhere that Esteban was a clarification of the regulations, and I was unclear where he got that from, but I did go back through the briefs, and we never used that term, but I will point out that both the appellant at the board and in our briefings to this court argued several times that Esteban does not apply, never argued that Esteban applies. The original Q motion specifically asserted that they failed to rate a separate disability based on the presence of separate symptomatology. With regard to Lamb, again, I want to reiterate that if the court determines that it stands for the proposition that the very first or original interpretation represents a change in law, then it should be overturned as it is inconsistent with other case law, in particular all of them that we have been discussing in this case. I would point to, again, Jordan and even Lamb itself, where the court ruled in Lamb that there was no Q because the legal rule that the appellant was trying to establish as Q did not exist when the regional office made its decision. In Lamb, the appellant was trying to apply the court's ruling in Hyson, which discussed the presumption of mailings and rebuttal, and that just didn't exist in 1957, and that was the basis of the Lamb court's decision. At no time did the court in Lamb ever say or rule that the very first or original interpretation represents a change in interpretation. And I think that the impetus of this confusion or presumably presumed confusion is the use of the term novel or new. And I would say that a novel interpretation can only represent a change in law when it, again, departs from the original interpretation. And the secretary, in response to the secretary's assertion that every precedential opinion will become a Q factory, I would just echo what was. I would just echo. I think it was Judge Toth who said that the correct application of the law should not be I'm sorry, that the secretary's interpretation would mean that there could never be Q until a court or the secretary told us what a regulation means. And that would be that would render 5109A, which authorizes reversing a decision based on Q in the RO's decision, or 7111 essentially without any force at all. So in conclusion, I would just again say that the Secretary is asking this court to announce a rule of law that both incentivizes the Secretary from ever interpreting a regulation or statute and also insulates his decisions from a collateral attack based on Q when he fails to interpret these laws. He also asks this court to inoculate him against any court decision that provides the original interpretation of a law. Such a ruling would create a system that allows vague regulations that are incomprehensible to the claimants and allows arbitrary adjudication by the VA with no clear standards. Such a system would remove a critical tool that allows veterans to ensure the VA correctly applies the law. Congress mandated that any prior final decision shall be reversed on the basis of Q. Congress's intent in sections 5109A and 7111 was to correct clear and unmistakable errors. That intent should not be impeded by a ruling by the full court that an original interpretation of a statute or regulation constitutes a change in law. Thank you very much.
Do any of the judges have any questions for Mr. Dohakis? Okay, hearing none. Rebuttal is complete. Thank you, Mr. Dohakis. And thank both of you, Mr. Dohakis and Mr. Kirshner, for your arguments. The case is submitted for consideration.
The court is in recess.